Hello, everybody. Welcome to today's episode of Courts This Week on Live Law. I am Tanya Pandey, here with your weekly update of the most recent judgments from courts in India. As usual, let's begin today's episode with top stories from the Supreme Court. On the basis of a report in the leading daily newspaper that convicts lodged in Agra Central Jail had not been released on interim bail even after 3 days of the order granting bail, the Supreme Court has taken suo motu cognizance of the matter. The newspaper reported that the delay was caused because prison authorities were awaiting receipt of the Supreme Court order by post. On July 8th, the Supreme Court had passed orders for immediate release of 13 prisoners on interim bail after finding out that they had been languishing in jail for periods ranging from 14 to 22 years, despite establishing that they were juveniles at the time of offence. The bench of CJI N.V. Ramana and Justices L. Nageshwar Rao and A.S. Bopanna observed that the Supreme Court was thinking of implementing a system to electronically transmit bail orders to prisons so that the release of prisoners on bail will not be delayed. The court has sought from the state governments details of whether efficient internet facilities are available in their respective prisons. The bench also directed the Secretary General of the Supreme Court to submit a proposal suggesting the modalities to implement faster system within 2 weeks. The Supreme Court has upheld a judgment of the Madras High Court, which held that an ex parte decree passed against a minor not represented by a guardian who is duly appointed is a nullity. The High Court was dealing with a revision petition filed under Section 115 CPC against the refusal of the trial court to set aside the ex parte decree passed in a suit seeking specific performance of a sale agreement. The trial court had dismissed the application to set aside the ex parte decree on the ground of unexplained delay of 862 days in preferring the application. One of the defendants in the suit was a minor. While considering the revision, the High Court had summoned the records to ascertain if the guardian was duly appointed as per procedure. On finding that there was no proper appointment of guardian, the High Court set aside the ex parte decree as a nullity without going into the question of adequacy of reasons for delay. The Supreme Court held that the failure to appoint a guardian will result in prejudice to the minor and it need not be specifically established. Further, the Supreme Court agreed with the High Court's view that the decree as a whole required to be set aside and not merely against the minor defendant. The Supreme Court has observed that violation of Section 25F of the Industrial Disputes Act 1947, which provides conditions precedent to retrenchment of workmen, would not automatically entail reinstatement with full back wages. In this case, Panchamlal Yadav had challenged his termination from Bundelkhand Kshetriya Gramin Bank before the CGIT, that is the Central Government Industrial Tribunal. CGIT held that he was not a regular employee as he was employed on daily wages and that he could not prove that he had continuously worked for more than 240 days in a calendar year. This order was challenged before the Madhya Pradesh High Court. A single judge of the High Court allowed the writ petition and directed Yadav's reinstatement with full back wages. The bank approached the apex court, contending that Section 25F does not automatically entail reinstatement with back wages. The top court held that Yadav was not entitled for reinstatement but directed the bank to pay him a compensation of Rs 5 lakh. The Supreme Court on 16th July observed that religious sentiments are subservient to the fundamental right to life and health in the suo motu case taken against the decision of the Uttar Pradesh government to allow the Kamar Yatra pilgrimage among the COVID-19 pandemic. While the neighbouring state of Uttarakhand decided to call off the Kamar Yatra, citing the pandemic risk, Uttar Pradesh had decided to allow the pilgrimage yatra with certain curbs. The bench asked the Uttar Pradesh government to reconsider its decision to allow the physical Kamar Yatra. In light of this order, the Kamar Sangh on 17 July called off the Kamar Yatra in Uttar Pradesh after holding consultations with the government. On May 7th, a slew of directions were issued by the Supreme Court to decongest prisons during the second wave of the COVID pandemic. On 16th July, the court has ordered that all prisoners who have been released by the high-powered committees of the states in the wake of the COVID pandemic pursuant to the May 7th order in the Suomoto case, should not be asked to surrender until further orders. The court also directed all state governments to submit a report detailing how the May 7th order was implemented and the criteria adopted by the HPCs to release the prisoners on emergency parole. The Supreme Court has held by 2:1 majority that the minimum age limit of 50 years prescribed by the Tribunal's Reforms, Rationalization and Conditions of Service Ordinance 2021 for appointment of members in various tribunals to be arbitrary and discriminatory. A 3-judge bench of Justices L. Nageshwar Rao, S. Ravindra Bhatt and Hemant Gupta was delivering the judgment in the fresh writ petition filed by the Madras Bar Association this year challenging the Tribunal's Reforms Ordinance. Justice Hemant Gupta dissented from the majority and dismissed the petition. The Supreme Court on 14 July delivered the judgment in a batch of special leave petitions filed by Franklin Templeton against a judgment of the Karnataka High Court, which had restrained Franklin Templeton from winding up the debt funds without obtaining the consent of investors. The top court has agreed with the views of the High Court, but it has said that the requirement for consent of majority of shareholders will be after the publication of notices. The court further stated that it has upheld the validity of the regulations, and while doing so, it has held that in case trustees wrongfully seek winding up, SEBI will have the power to intervene in the same. The bench of Justices S. Abdul Nazir and Sanjeev Khanna also observed that legislations that are forbiddingly excessive or disproportionate can also be manifestly arbitrary. The bench, however, held that SEBI Mutual Funds Regulations 1996 under challenge do not suffer from the vice of manifest arbitrariness. The right to summon documents has to be exercised when the trial is in progress and not when the trial is completed, the Supreme Court has observed while allowing an appeal filed against a judgment of the Telangana High Court. In this case, the trial court had rejected the application for summoning of the documents. The High Court, in its revisional jurisdiction, reversed the decision of the trial court. Assailing the High Court order, it was contended that the trial had already completed long ago and the accused was examined under Section 313 CRPC and the application for summoning of the documents was moved only after that. Perusing the trial court order, the bench of Justices A.M. Khanvilkar and Sanjeev Khanna noted that it had given sound and tangible reasons for rejecting the application for summoning of the documents, which had been moved at such a belated stage and without any justification for such relief. Let us now look at the latest High Court judgments. Settling conflicting views, a full bench of the Madras High Court has held that an order passed by a Sessions Court denying bail to an accused under the Unlawful Activities Prevention Act can be challenged only by way of an appeal under Section 21 of the National Investigation Agency Act. Applications under Sections 439 and 397 of CRPC are also not maintainable against the rejection of bail by the Sessions Court in a UAPA case, the court clarified. The bench of Justices P.N. Prakash, V. Sivagnam, R.N. Manjula answered the reference based on the precedent laid down by the Supreme Court in Bikramjit Singh v. State of Punjab, wherein a 3-judge bench of the Supreme Court had held that all scheduled offences under NIA Act, which include UAPA, are to be dealt with in accordance with the procedure under the NIA Act, even if such cases are investigated by the state police and not the NIA. The Allahabad High Court has held that only the local police or the Special Juvenile Police Unit could serve notice on bail applications for offences under the Protection of Children from Sexual Offences Act, that is the POCSO Act. It also prescribed a timeline to execute the different statutory functions by the respective authorities. A bench of Justice Ajay Bhanot enumerated a 9-point direction to ensure regular monitoring of the implementation of the directions in this judgment, including the creation of standard operating procedure, supervision of staff, preparation of a biannual report, etc. The Delhi High Court found RTI activist Saket Gokhale's tweets against former Indian Assistant Secretary General to the United Nations, Lakshmi Puri, calling her a black money hoarder, etc., with respect to her disproportionate assets allegations, to be prima facie defamatory. Issuing summons in the main suit, the court has also restrained Gokhale from posting any further defamatory material against Puri and directed him to file his written submissions and denial affidavit, if any. Observing that sexual violence against women is an unlawful intrusion into their right to privacy, the Telangana High Court has upheld the detention order passed against a 22-year-old accused of stalking women, voyeurism, and allegedly inducing them to do nude video chats. Noting that to show mercy in such heinous crimes would be a travesty of justice, a division bench of Justices A. Rajashekhar Reddy and Shamim Akhtar dismissed the habeas corpus petition filed by the mother of the accused and observed that the detaining authority was justified in passing the impugned detention order. The Bombay High Court on 17 July directed the Mumbai police to protect a 23-year-old person identifying as a transgender male from being forced to leave the city at the instance of the parents. The court also directed the police not to take any coercive steps against him. A division bench of Justices S.S. Shinde and N.J. Jamadar granted interim relief in a plea filed under Article 226 of the Constitution of India. The petitioner said that they apprehended a threat to their safety from their parents and the police. The court has granted the interim relief sought and listed the matter for hearing on August 8. The Himachal Pradesh High Court has denied bail to a 32-year-old woman for allegedly inducing a minor girl into flesh trade with strangers. The court observed that both the society and the state have failed to take responsibility in such cases. The bench of Justice Anup Chitkara observed that prima facie the allegations pointed out towards the petitioner, who was the main accused, and that she had acted like a pimp and was not entitled to any bail. The Allahabad High Court has quashed disciplinary proceedings against a pilot petitioner regarding an aircraft accident in 2008, calling it illegal, arbitrary, and an abuse of the process of law due to unexplainable delay and the arising apprehension of mala fide therein. The bench of Justice C.D. Singh ordered reinstatement of the petitioner in service with all consequential service benefits. The court noted that in case of a deputation, the borrowing department does not have the jurisdiction to terminate the services of the employee, and that the report based on which the charge sheet was filed did not indicate an error on the part of the pilot or negligence in following the due procedure. That's all for today's episode. I'll be back again next week. If you want to stay updated about the most recent news from Indian courts, do subscribe to Live Law and click the bell icon to not miss any videos from us. I hope you're taking good care of yourself. I am Tanya Pandey for Live Law. Have a great week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.